restrainted trades, they really do cause a lot of problems. I critique a lot of employment agreements for workers, and I find that they sign them off when they start a new job willy-nilly, and it causes them hell on earth. So we're back here with Chris Patterson again. Yeah, a good mate. And look, and of course a barrister and somebody highly recommended to give some advice on this. So can you explain what a restraint actually does?
Yeah, good morning, Max. All right, well, a restraint's one of the few aspects. In fact, there's actually only one aspect that survives the end of an employment relationship, and that's an ongoing duty of confidentiality. So restraints are contractual agreements between an employer and an employee that says, when the relationship's over, you, the employee, won't do certain things. That's the essence of a restraint.
And primarily, my experience is, the restraint actually forbids them for stepping into a role very similar to the one they had with a competitor, and that really does restrain people. I've had some people come to me and they really can't work for 6 months unless they go and get some other menial job, and they're reasonably skilled.
Yeah, okay, well, look, restraints come in various forms. So at a real basic level, you could have a restraint that says to an employee, or an employee agrees, look, I won't go and try and encourage your employees to come and work for me or work for a business that I might become associated with. The restraint could go further and say, look, I won't do the same thing with your customers or your suppliers. Or it might even go to the extreme, which is actually I just won't get involved in the industry at all for a period of time. So restraints come in different forms.
Very true. Very true. So the three I always see is the one that you just talked about, and that's you're restrained from actually taking one of our employees away or tempting them to go away. Sure. And two is you're restrained from touching our current customers. And those both seem reasonable to me. But the third one seems difficult, and that is that you're not to go and work for a competitor and take those skills that maybe you learned from here on further to that competitor.
Or even the industry itself.
That's pretty wide, and that does happen.
Yeah, you can have two businesses that are in the same industry but aren't actually direct competitors. Yeah.
So, well, folks, let me just tell you too, because Chris is aware of this as well. There is a bill going, it's going to be proposed to Parliament, and it's been pulled out of the ballot, and it's politicians are going to have to get consideration. And personally, I quite like some of it. Some of it, I think it does need to be curtailed. But anyway, this is the four fundamental facts. If I can just sort of go through them quickly. The restraint means it will have no effect on any employee if they earn less than 3 times the minimum wage. 3 times the minimum wage, I think, must be about $60,000. And that's getting up there. So that means it can't be imposed on anyone less than that. And if an employer has proprietary interest, now we need to talk to Chris on that. What is a proprietary interest? And if the employer's got one, then the restraint has limited effect. And then if a restraint is put on an employee, then any restraining period, there should be at least 50% of the worker's pay paid to that employee for the period of restraint. And of course, the maximum duration, this bill says it can be 6 months, and Chris and I have seen them for 12 or sometimes more, I think even. So what's a proprietary interest, Chris?
Okay, well, look, Max, before I answer that, I think maybe it's actually worth just talking a little bit about the bill that you're mentioning. So it's a private member's bill. It's been brought by Helen White. She's a List MP. She competed at the last election for Auckland Central. She's unsuccessful with that. Her background is she's an employment lawyer. You may have come across her.
Often.
You've come across her. So, it probably a little pet project for her. She's thought about something that she thinks is important and put into, it's actually a feature of our democratic system, which is the ballot for a private member's bill. Now, for some listeners who don't know what that actually means, what that means is that any MP can draft up a proposal for a bill, put it in it's not literally a ballot box, but it's a form of ballot box. And then during the parliamentary sittings, bills will randomly be pulled out of the box. And if you're lucky enough, in Helen White's case, she's been lucky that this one has been pulled out. So it then actually starts the legislative process towards becoming a piece of legislation. But at this stage, it's at a very early stage, and we do have an election coming up in September. If there is a change of administration, my view is that the bill will never see the light of day. It will not become legislation, but it might, okay? And if it does, then the points that you're raising are all valid and correct. And it also possibly goes back to one point that I've made in the past, and that is I do think where you've got a body of case law, it's good to have some codification so that people know what the rules are. They don't have to dive into hundreds of legal cases. I mean, there's an exaggeration when it comes to restraints of trade. You actually only need to look at about five of the leading cases. You get a general feel for it. But, I think that's a good idea. Is it a good use of our legislative system? I think not. There are other private members' bills that are working their way through that I think are far more important for employers, including Duncan Webb's bill on defining directors' duties. I think that'll have a much bigger implication to small businesses and medium-sized businesses in New Zealand. But, okay, so that's the background to how it works or doesn't work. Your question is, what's a proprietary interest? Great question, heavily debated in court, because it is the starting point for any restraint. Should I say the starting point is, restraints are illegal. Okay, under our old Legal Contracts Act, they'd get struck out. Under our Contracts and Commercial Law Act, they can be upheld. But for them to be upheld, there has to be two elements. And one of the elements is there must be a proprietary interest that needs to be protected.
And what is that, Chris?
Yeah, okay. So businesses have proprietary interests in lots of things. But for most businesses in New Zealand, I think it goes without saying, they've got an interest in their staff, and that is keeping the relationships with their staff, because they may have invested a lot of money to get the staff and to keep hold of them. And they've got an interest in their customers, so there's an interest in their customers, keeping their customers, not losing them. And to a lesser extent, sometimes there's a real interest in their suppliers and keeping their suppliers. Now that interest is something that an employer may have invested a considerable amount of time, energy and resources into. So, for example, if we just take staff, an employer may have paid a recruitment agency several thousands of dollars, maybe tens of thousands of dollars to recruit a particular person. With a customer, they may have spent years to secure the first order from a customer, going and visiting them. They may have also provided services or goods at a discounted rate to bed in the customer. So those are relationships, and I think that's in essence where I'm getting to, is the proprietary interest for most small New Zealand employers is in a relationship of some form.
Yeah, and my understanding of it was that a proprietary interest is where an employer can prove and show that they've got some particular interest in their whole industry or business or their technicalities. And I mean technicalities, they've got some particular unique skills or whatever that need protecting. They own it, they've got it. That employee could take that away and immediately dilute the value of that and actually give it to their competitor. And that's where they say, hey, I've got something pretty unique here and I need that protected. Am I on the right grounds
well,
there?
Yeah, look, you are. I mean, if you're alluding to, for example, the concept of trade secrets, certainly are a proprietary interest, but they can be protected through different means.
Confidentiality.
Through confidentiality, through, for example, registering a patent.
And let's just go through that. Confidentiality is an implied term of an employment agreement, so it doesn't even have to be in writing, but every employee has to carry that beyond their termination of their employment.
Yeah, it's the only term that is implied, and when we say implied, it doesn't need to be expressed in writing, that will survive the termination of an employment relationship. Because generally speaking, when an employee resigns or an employer terminates, fires an employee, it's all over. Okay, neither party owes each other any ongoing duties other than this issue of confidentiality.
No, I know restraints are quite complicated because we've seen, coffee carts, for example. And that's a famous case. I think
Yeah,
you know what I'm alluding to, the Wellington one. And of course, those common skills, those other things, and where employees restrained from actually getting another job down the road, and they really don't have the trade secrets that we've been talking about.
Sure.
That seems to be unjust. And the good thing about this is there's a fair bit of leeway for the judiciary in these matters, isn't there? They can. It's not on the pure reading of the contract. They've got to examine all the facts and then apply. What is it?
It's got to be it's got to be reasonableness
and good faith. Yeah.
Okay. So once a
fair and reasonable. Those are the two keys.
Yeah. So once a proprietary interest that needs to be protected is identified, okay, and we'll just use the example of a customer base. Okay. Once that's been identified, the question is the restraint, the scope of the restraint, is it reasonable? And that is that it can't be any wider than is necessary to protect that. So using the example of a customer base or client base, is that you have the concept of a notice period. If an employee resigns, there'll be a notice period, and that notice period generally should give an employer enough time to familiarise themselves and renew their relationships directly with their customers, because it may be that the employee who resigned was the account manager. They were the face of the business with the customer, okay? And they may have been the account manager for 10 years, okay? So the relationship at the end of the day is actually between the outgoing employee and the customer, even though legally it's with the employer. Okay, so the notice period may be insufficient to enable the employer to say, okay, well, first of all, I've got to get another accounts manager, and they may or may not have anyone already as part of their team that can take over that role. They may have to go and recruit someone, so they're going to need a period of time. The notice period might not be enough. So they could say, well, we actually need a restrainer trade for 3 months or 6 months to keep this outgoing account manager away from our customer. It's our customer. They'd never have had the relationship but through us, okay, so that we can put a new account manager in to form a new relationship, so that when the outgoing account manager is then in full-on competition, it's more of a level playing field, where the advantage that the outgoing account manager got because of us, inherent in the role, we paid them for it, okay, that they can't use that advantage against us.
And Chris, that's where I see the reasonableness of a restraint, particularly with sales reps who do have the relationship. And look, I've even been a manager of a business where the sales rep took off and grabbed those people, and we had to go for the restraint, which is not an easy process. I've got to say, for an employer, it's not an easy process to enforce a restraint because of that vagueness that's in there. And look, folks, if you're listening to this and listening to what Chris is saying, the proprietary interest is not an easy thing to define. And in my experiences, Chris, particularly with the Employment Relations Authority, which is a low-level judiciary, the definition of that is just all over the place sometimes, and you cannot have confidence that the definition that you thought it had is going to be affected.
Oh, well, look, an analysis of the case law is that there isn't a golden thread or a bright line. There's a lot of inconsistency and lack of cogent definition of proprietary interest. I don't think if this bill goes through, it's necessarily going to shed a lot of light on that to a degree. There's still
no definition in there of it as well, I know.
So that's a real issue. Look,
what about the monetary ceiling on it? So anybody who's earning, only people, who are earning above 3 times the minimum wage can actually take use of their restraint.
Well, I actually think it's actually a good indicator of where Helen White's thinking is on this.
I agree. And
if the thinking was we want to clarify the law so that there's less litigation, for people earning that to a degree, that might be the case. But if the purpose is actually to ensure that legitimate rights are protected, and that people have a better appreciation of it, it misses the mark. because the reality is that a worker on not much more than minimum wage can possibly inflict more economic harm on an employer than someone earning 10 times that amount.
I totally agree.
The money's irrelevant, okay, to the harm that can be inflicted. But look, Max, one thing that I do think is also worth covering off is that restraints also play quite an important point, and this is just my experience because I've been involved in quite a few of these campaigns, and that is in the area of where you have two businesses. One business wants to buy the other one out or would like to acquire its client base, for example, but doesn't want to actually pay for it. Okay, so what's a great strategy to do that? Well, you just go and poach the key staff, and then you can save yourself hundreds, if not millions of dollars of actually buying what the business is actually worth by literally raiding its key staff members. Restraints are a way of protecting that particular interest. And I've seen that a lot over the last 25 years.
You put that in really good context, Chris, because that actually does give the dimensions of it. And if you are if you're a competitor, they're always looking over their shoulder and saying, well, what can I do to that opposition of mine? So you're quite right, that is effectively what does happen.
Yeah, so look, one aspect that is worth keeping in mind is that the restraint of trade issue isn't just a binary aspect between an employer and an employee. It is something that's relevant for other industry participants, and that is and in the way I've just explained, but also I think it's worth for an employer who's looking at recruiting someone to actually say to them, are you subject to a restraint of trade? Because if it turns out you employ someone who's subject to a restraint of trade, you could be inheriting a bit of a nightmare, potentially, and under our law you can be sued for aiding and abetting a breach of an employment agreement. So it's something that's worth keeping in mind.
And likely to. Hey, Chris, there's you might have seen it a while back, but there was a case where the employee failed to notify his new employer that he had a restraint on the previous employer.
Yeah. And
the new employer took an action against him, saying that you failed in your duty to notify us of that restraint before you came aboard. Now that, I often tell my people about this, you must tell, your legal obligation is to notify your new employer that you've got this restraint. Really? I said yes.
Yeah, although it's a little bit of a catch-22 because to be sued for aiding and abetting or the tortious claim of unlawful interference in contractual relations that can pop up, although it's only in the High Court it's really run. You've got to have, as a new employee, you've got to have knowledge. So sometimes ignorance is actually a defence. You're not really aiding and abetting if you don't know. There's a knowledge component to it. Yeah.
Oh, that's why we got you here, Chris, because, I mean, I didn't realise that other action that it was deemed a tort and probably in the High Court too. So thanks, Chris. That's enlightened myself as well. So
the reason, Max, why that's important is that the employment relations institutions, their exclusive jurisdictions only between an employer and an employee, other than that limited area of aiding and abetting. Beyond that, for if you need to drag another company in who's not in that employment relationship, you've got to do it through other means, and one means is to bring effectively a civil wrong claim, so a tort claim, for example. Yeah.
Well, we're going right off subject here because I was really going to bring in something. There is one other circumstance, in my understanding, and that's where they buried the Employment Relations Act. And that, by the way, is probably, you're correct, it's another employer. So this is where temp agencies put somebody into another effect. But look, we're going off subject here.
Sure, yeah, absolutely.
Well, look, is there anything else? And look, your point on the restraints is I actually think it's quite, because I see it happening every day.
Yeah.
Employees just sign off on them because they have no problems. They're so excited about getting this job and they put a restraint and accept a restraint. And quite often I advise and go, please don't sign this with this restraint in it.
Well, okay. Well, Max, there is actually a point with that. I mean, this is a practice of using boilerplate clauses in contracts.
Correct.
Some employers, in my experience, actually don't even know that they're there. they've just been there for for years, and they're there, and both parties are somewhat blissfully unaware of what they're signing up to. So be it. But an important legal matter that it's worth people knowing is that on the reasonableness, it's not just the scope, but they will look at what consideration was paid. And the reasonableness is assessed at the time the parties entered into the contract. It's not it's not 10 years later, okay? So they will look at it and say, well, if the employee, for example, had been fired the day after they were employed, or even resigned, would it be reasonable to restrain them for 3 months, 6 months, 12 months at that point? Well, no. Well, then that doesn't change over time because it's looking at the time that's there. One thing which might be worth mentioning is in Australia, the Australian courts have approached the issue of time, that's the length of the restraint, in kind of a novel way, so that it's led advisors or people drafting agreements to use what I call a waterfall clause, and that is to say, if you're employed for 3 months, then your restraint is 1 month, and it progressively gets longer. But it then goes on to say that if for any reason, a court of competent jurisdiction deems the length too long, then the length will be 2 months less, or 3 months less. So it actually contractually gives the judge the power to point at the contract and say, well, this term has been agreed by the parties and it's reasonable. Whereas in New Zealand, we haven't got to that stage. It hasn't been tested yet, but the day may come where they say, well, 12 months isn't reasonable, so you should strike the whole thing out, full stop. Okay, even though 9 might have been reasonable. Yeah.
I have seen it happen here.
Yeah.
The courts will, the authority will intervene in saying a 12-month restraint is too much. We will empower it for a 6-month period.
Yeah.
Hey, Chris, just before we go, we should touch on it just for the viewers, is that the other issue is that restraints are not just for employment relationships either. They are also enforceable in commercial relationships.
Absolutely, yeah. Look, 100%. In fact, you will find far more restraints in commercial relationships than you'll find in employment relationships, in my experience.
And they are enforceable, or the same rules apply?
No, the same rules apply, but they are certainly far more. And the most common area is the sale and purchase of a business. So, generally speaking, the vendor, the person who's selling the business, will have some form of restraint for a period of time. Because otherwise, they can take a lot of money from the purchaser and then just go and set up in competition across the road.
Hey, Chris, really good to see you.
Great to be here.
Come back and we'll do another
Thank
good
you.
subject, because this was a beauty in my view.
Yeah, fantastic. Thank you, Max.